Hello everyone, I hope you are doing well. In this particular video, I will discuss about the historical journey of Indian legislation related to trademarks, designs, geographical indications, semiconductor indicator circuit and layout designs, plant variety, traditional knowledge, biodiversity and trade secrets. So let's start with trademarks. As you know, trademarks are the marks, logos, symbols or brands of a particular company. In India, the first legislation in respect of trademark was the Indian Merchandise Marks Act 1889. Along with that act, disputes related to infringement of trademarks was solved under the Specific Relief Act 1877 and registration problem was tackled by Indian Registration Act 1908. The Indian Merchandise Marks Act 1889 was replaced by the Trademarks Act 1940, and this act was based on the Trademarks Act of 1938 of the United Kingdom. This act introduced the system of registration of trademarks and provided statutory protection to registered trademarks. To handle the administrative tasks related to registration and enforcement of right, Trademarks Registry was established in 1940. In 1958, the Trade and Merchandise Marks Act was adopted by replacing the Trademarks Act of 1940. According to Section 129 of this Act, any document declaring the ownership or title of a person to a trademark other than a registered trademark was not to be registered under the Indian Registration Act 1908. The 1958 Act did well for 4 decades. However, as the globalization of trade and industry increases rapidly, a need was felt to make a comprehensive review of the 1958 Act. Also, as India became a party to the TRIPS agreement, it became mandatory to bring trademark law at the same page with the provisions of the TRIPS agreement. Accordingly, the Trademarks Act 1999 was adopted and it came into force on 15 September 2003. The Trademarks Act 1999 provides statutory remedies as well as remedies for the unregistered trademarks. It is the current governing law of trademark in India. Now, certain amendments were made in the Trademarks Act to comply with the Madrid system for international registration of trademarks. Trademarks Amendment Act 2010 was passed on 21st September 2010 to bring into force the Madrid Protocol system in India. In 2002, Trademarks Rule was introduced to deal with the various proceedings to implement the provisions of Trademarks Act of 1999. Industrial designs are the creations of human mind, which are appealing to our eyes and attract the attention of the viewers. The need to protect the industrial designs was recognized in the 18th century, and in India, the first legislation related to designs was the Patents and Designs 1872. This act provided the inventors an exclusive privilege of making, selling and using new patterns and designs in India for a shorter duration of time. This act was replaced by the Indian Patents and Designs Act 1911. This act was inspired by the British Patents and Designs Act 1907. The Indian Patents and Designs Act 1911 served as the main governing law of patents and designs over 6 decades. In 1970, Patents Act was introduced to take care of the patents. However, the protection of designs was governed by the Indian Patents and Designs Act of 1911. In 2000, Design Act was introduced for protection of design and to comply with the Articles 25 and 26 of TRIPS Agreement. Currently, the registration and protection of industrial designs in India are administered by the Design Act 2000 and the corresponding Designs Rule 2001. Both the Act and rules came into force on 11th May 2001. The Designs Rule 2001 was further amended in 2008 and 2014 by Design Amendment Rules. The latest amendment in design rules came into force on 30th December 2014. It incorporates a new category of applicant as small entity in addition to natural person and other than small entity. Now, geographical indications or GI tag are used on products which belongs to a particular geographical location. Now, before 1999, there was no specific law in India on geographical indications. After the Basmati rice controversy, India realized that we need to protect our geographical products. So, according to TRIPS agreement, India needed to make a law to protect the GI products. Therefore, the Parliament of India enacted the Geographical Indications of Goods Registration and Protection Act 1999. This act came into force from 15 September 2003 along with the GI rules 2002. Geographical indications have been defined under Article 22(1) of the WTO Agreement on TRIPS. Trade secrets is any practice or process of a company that is generally not known outside the company. In India, there is no specific legislation for defending or protecting trade secret. However, rights in respect of trade secrets are enforced through contract law such as Indian Contract Act 1872 and other law like criminal law, common law, principle of breach of confidence and equity are also used for governing these trade secrets. In the later part of 20th century, rapid scientific advancements in the field of information technology resulted in the creation of a new class of IP which is known as the Semiconductor Integrated Circuit Layout Design or SICLD. A diplomatic conference was held at Washington DC in 1989 which adopted a treaty on intellectual property in respect of integrated circuits. This treaty is known as the Washington Treaty. It was signed on 26 May 1989 and it has been incorporated in the TRIPS agreement. Being a member of the WTO, India enacted the Semiconductor Integrated Circuit Layout Design Act or SICLD Act 2000. This act fulfills the condition of TRIPS agreement in Articles 35 to 38. The SICLD Act came into operation from 4th September 2000 and the SICLD Act and the SICLD Rules 2001 provide the protection of semiconductor integrated circuit layout designs. Till 1970s, there was no such importance on patentable matter originating from animals and plants. However, microbes and microbial products and processes were patentable. To include all kinds of biological materials under the patent law, International Convention for the Protection of New Varieties of Plants or in short UPOV was established. UPOV is a treaty body with headquarters in Geneva, Switzerland. Its main objective is to provide an effective system for plant variety protection. UPOV was established by a convention in Paris in 1961 and the UPOV convention was revised in 1972, 1978 and 1991. The TRIPS agreement made it mandatory for WTO members to introduce plant variety protection in national laws. So, to comply with the Article 27(3)(b) of TRIPS agreement, India adopted PPV and FR Act in 2001, which is Protection of Plant Variety and Farmers' Right Act. So, this act was implemented to protect not only the new plant varieties but also protect farmers' right. This act came into force on 30th October 2001. The procedural details about the registration and implementation are provided in the PPV and FR. Traditional knowledge is the ancient and indigenous knowledge held by any community or a group of people. In olden times, it was not recorded anywhere and was available only in the oral form. So, traditional knowledge was verbally passed on to future generations. Although there is no official record, but some form of sticke find appearance in the culture, stories, folklore, rituals, songs, etc. Previously, there was no mechanism available to protect the traditional knowledge, but now it has been recognized as IPR under TRIPS agreement. The Government of India has created a digital library, which is a repository of 250,000 formulations of various systems of Indian medicine. This library is called the Traditional Knowledge Digital Library, or TKDL. TKDL was established in 2001 to prevent exploitation and to protect Indian traditional knowledge at patent offices worldwide. Biodiversity is an inseparable part of human livelihood. The mention of protecting biodiversity can be found in the times of Chandragupta and Ashoka. In those times, the trees and forest were classified as reserved category. In India, there are several legislations which were enacted for the conservation of biodiversity and to provide legal protection of biodiversity. For example, Indian Forest Act, Wildlife Protection Act, National Forest Policy, Mining and Mineral Development Regulation Act, Water Act, Forest Conservation Act, Biological Diversity Act, Scheduled Tribe Forest Dwellers Act, National Biodiversity Action Plan, National Environmental Policy, etc. United Nations Convention on Biological Diversity is a multilateral treaty for the conservation of biological diversity. It was signed in Rio de Janeiro on 5th June 1992 and entered into force on 29th December 1993. Its main objective is to develop national strategies for the conservation and sustainable use of biological diversity. In India, the Biological Diversity Act was enacted in 2002 for preservation of biological diversity. It provides mechanism for equitable sharing of benefits arising out of the use of traditional biological resources and knowledge. This act came into force on 1st October 2003. It was enacted to meet the obligations under the Convention of Biological Diversity because India is a member of the CBDTT. Okay, thank you and thank you for watching.